Present.
Commissioner Bluestone,
Here.
Commissioner Castillo,
Present.
Commissioner Klingman.
Here.
If not visible, he is audibly with us. And Commissioner McMillan.
Here.
Thank you. Commissioner Villanueva.
Here.
And the chair is here. Item number 2, approval of the agenda. Is there a motion and a second?
Move to approve the agenda.
Second.
Thank you. Any discussion? Is there any opposition to approval of the agenda? Thank you. It's deemed passed. Item number 3 is approval of the minutes of our last meeting, which was held on February 13th of this year. Is there a motion and a second to so approve?
So moved.
Second.
Thank you. Any discussion or seeing none, anybody opposed to approval of the minutes of the February 13th, 2026 meeting? Hearing none, they are approved. Okay, now on to slightly more meaty matters. Item number 4, approval of the fiscal year 27 operating budget. Jeremy, you and Wendy have this.
Thank you, Chair. Good morning, Commissioners. We have an interesting meeting for you today, which starts with my statutory duty to prepare a yearly budget for you to submit for your approval. And so as part of your materials for today, you have the FY27 operating budget that really Wendy and Sharon have done a lot to put together. I've helped some on that. This is a budget for 1.92 million. We're still kind of under that $2 million threshold, but it's a huge growth since when we started. About 86% of that, 84%, I should say, is for our staff. And one of the changes over the past years is that the state is now contributing an 80%, 20% match on healthcare, on health insurance costs, and that's changing some incentives for employees to come on with getting their health insurance through the state, and that's shifted the responsibilities that we have as an agency to cover our 80% share. And so our costs in the 200s have risen, and Wendy and I have had to kind of be careful with planning for that. And so our 200s expenses are up to 1.61 million. I'll say another thing about our 200s plan for FY27. As the commissioners know, Casey is on maternity leave and will take up to 40 weeks of unpaid leave. And so that would create a kind of a bit of savings in the 200s that we really don't want to accrue. And so we're thinking about other useful ways to expend that 200 budget while Casey is out. And so Wendy and I have created a set of temporary positions through SPO, which we have filled for our summer associates, who now will not only work through the end of the FY26 fiscal year, but they'll carry on through August when they go back for their second and third years of law school. And so we're using some of that accrued savings to pay law students to work here longer through the summer. And then we've also created another intern position to give an undergraduate student an opportunity to come in and do some work here at the commission in some support and administrative roles. And we've inherited a lot of papers from Dee Dee Feldman and Cliff Rees that relate to the history of this commission. And we kind of need an undergraduate to come in and help us kind of archive and organize all those materials. And so that's how we're thinking to kind of the whole that's otherwise created by affording the opportunities that we afford at the agency for parental leave. And so those are, just the kind of comments in the ways that our 200s budget is different this year. The commission might notice that our 300s budget, our contracts budget is lower. The LFC has gone in and chipped away at the appropriation for contracts. And that budget category is now getting rather tight because we're also seeing contract increases, especially from our auditors. The CLA has increased the price of the work that they do for us for the financial statement in the yearly audit. And so I don't anticipate that we'll be reverting very much from the 300s. And in fact, because we use part of that budget to fund litigation expenses and in particular court reporters, we might be kind of backfilling that over FY27. And then I think we have just enough in the way of 400s to cover our operating expenses. The largest item here is our lease payments to UNM. We have a couple of different offices here at the Science and Technology Park, and we afford very, very good office space for our staff, and that's the largest kind of category. We kind of absorb other cost increases from other agencies in the state. So the Department of Information and Technology kind of continually increases the cost that they charge us for their services. We kind of don't have another option there. And our premiums for risk management and the work that they do for us to bring Long Comer on board whenever the commission faces a claim. The more activity that we're involved in, the more claims that come against the commission, the more we have to rely on risk management and Long Comer, and that increases the premiums. So that's reflected to some extent also in the 400s. But overall, I think that this is a budget that we can live within FY27 to manage the work that we need to do on behalf of the state. And it's getting tighter, and I'm hoping that in the next fiscal year, in the next legislative session, we can maybe inch this up just a bit. But there you have it, commissioners. That's the FY27 operating budget. And Wendy's here with me this morning if you have any questions for particular account codes.
Thank you. Is there a motion, a second, to approve the operating budget as presented?
So moved.
Moved and seconded. Any discussion, questions? Stuart?
Yes, thanks. Looks good. Thank you for the hard work and the presentation. The only thing I'd like a little clarification on is the contractual services items. Could you just explain a little bit the difference between what goes under professional services and attorney services? You mentioned hiring Paul Biederman. I don't know if that comes under that area, or if you shift something under the salary items. But if you could just explain those, and then a little bit about IT services, because we do IT stuff under that next category, what you call the 400s. But I just wanted to get a little understanding of the difference between the $26,000 of IT services in the 300s and then the IT items in the 400s.
Absolutely. So starting with the IT expenditures that are coming out of the 400s are for services that DoIT provides to us. We purchase kind of Microsoft Office 365 accounts through DoIT. All of our phone purchases, our domain network is purchased through DoIT. All those expenses are funded through the 400s budget category. And if we have to buy physical IT supplies for staff, computers, laptops, phones, those are 400 type expenses. The 300 type expenses is our contract with Real-Time Solutions. And that's work that Real-Time does for us to build and maintain our website and our proceedings portal. So the portal is the online case management and docketing system. We now have online dockets for the administrative cases, all the informal complaints, the whistleblower complaints. those come in through the portal. They've recently built a search function for us because the agency is now at such a tenure that I can no longer remember 6 years of administrative cases down to the detail of the case. So we built a search function, Real-Time built a search function for us, and it's actually working great. We can go in and we can kind of query a name of a respondent or a complainant, and we can see, oh, well, that person also filed something back in 2021. And so that's the kind of work that Real-Time does for us. During FY27, we are discussing currently with Real-Time and are under contract and have obligated FY27 funding to add Relona to the portal. So we should have three lines of different kinds of dockets on our portal with Real-Time. That's all backed up on an Amazon cloud server, and we pay Real-Time through the 300s for that kind of work. So that's the IT services that you see in the 300s. The distinction between professional services and attorney services, that really divides on the difference between hiring an attorney to do attorney work, like Paul Biederman is doing with the commission now, versus the private hearing officers that we hire, such as Alan Torgerson. And so most of our hearing officer work goes through the Administrative Hearings Office, and we have an MOU with the Administrative Hearings Office, and you see that in professional services interagency, the line item, but the line item above that for professional services, that's mainly for Judge Torgerson, Alan Torgerson, to keep him on kind of on retainer, as it were, for hearing officer work in more significant cases. And right now, Judge Torgerson is the assigned hearing officer for the case of Castellano versus New Mexico Families Forward. So that's kind of where that sits.
Okay, so then Paul, you say, is under the attorney services item.
That's correct.
Okay, thanks for the explanation. Very clear. Thank you.
Anyone else? Jeff?
Yeah, Jeremy, did I understand you to say that the formula for medical insurance has changed?
It has. That changed 2 legislative sessions ago. The legislature did something that was a little unexpected. They increased the state's share of health insurance premium cost to 80%. So state employees pay 20% out of their paychecks for health insurance they take, and the agency picks up the balance of the 80%. And so that shifts a lot of costs for health insurance onto the state and the state agencies, which means that we have to figure that out. Initially, there was a funding for that was outside of HB2, and I believe that it wasn't quite enough. Wendy knows the details on that. So if it's ever not quite enough, we have to kind of figure it out and backfill it in our own budget. This year, I believe the funding for the 80% match was calculated into the 200s funding for HB2, but the calculations aren't always perfect, and sometimes agencies kind of get caught out a little. We're fine, but other agencies of a similar size or slightly larger, we've noticed, have not been fine and are in kind of budget crunches as they adjust to the 80% duty that we have to cover. But so far we're quite healthy, and we have Wendy to thank for that.
Thank you.
Anyone else? Okay, go ahead and call a question. There's a motion and a second to approve the FY27 operating budget as outlined and discussed. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Approved.
Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
And the chair votes yes. Thank you. The motion carries. Thank you, Wendy and Sharon, and thank you, Jeremy. Good work, everybody. And we'll note that a lot of the things that maybe our expectational interests were not met is that the budget the overall state budget was considerably smaller this year than in the recent past. So I'm sure that pain is being shared by all state agencies. Item number 5, House Joint Resolution 5, legislative compensation. Stuart, you had requested we have a discussion on this. You want to go ahead and move
Sure,
forward?
thank you.
Sure.
Yes, I've been asked if the commission would be endorsing this legislative pay constitutional amendment. And so I thought it was something that we as a full commission should consider. I hadn't really thought about it before, but I think there are reasonable pros and cons on both sides on the issue, and I'd like to review what I think are some of them. And on balance, I guess I do come out thinking that we should endorse it, primarily because I think the legislators deserve to be paid for the work that they do. And I think it's a good government measure that's consistent with our mission of promoting good government. And I think it may be helpful for some of the proposed ethics reforms, like for lobbying disclosures and financial disclosures. I know a number of other good government advocacy groups are supporting it, like Common Cause and the League of Women Voters. Personally, I'm very skeptical that the amendment itself will pass because I think other legislative proposals that have come up before to pay the legislature have not passed, and I'm not optimistic that it will pass the voters, but I think it should. And I plan to vote for it, and so I thought we as a commission should consider it. I've mentioned some of the pros. I mean, I think they do deserve to be paid for the hard work that they do, and I think you could even say that it's the right thing, it's the ethical thing to pay legislators for their hard work. I do think it will make the legislature more attractive to people from all walks of life, and therefore be a better representative government that results from being able to pay folks other than just for people who are independently wealthy or can retired or can afford to do this. I think it's quite possibly good for ethics laws, the ones that we administer and enforce, and in the sense that it can arguably reduce the incentive for money and corrupt practices to get money. I think it can allow for stronger ethics laws to reduce the influence of lobbyists and lobbyist money and lobbyists paying for meals and all kinds of stuff. And I think it could help promote more lobbyist disclosure laws like the ones we've been pushing for the last couple of years and have gotten very close, but haven't gotten over the finish line. And I think it could make it easier for some other ethics laws like campaign finance and financial disclosure laws to be improved. I think that the major cons against us doing it are that it's not strictly an ethics issue per se that the Ethics Commission should be weighing in on. I think that that's a legitimate argument. I actually also think it's unlikely, even if this passes, that it's going to make any real difference in the ethical conduct of legislators. I don't think we have any empirical proof to show that paying legislators solves ethics problems everywhere. I think there's also an argument that the legislators shouldn't get paid, that they already get the per diem that's pretty healthy, and that they get a very generous pension system, which a lot of people think also really was unconstitutional and shouldn't have been approved by the Supreme Court, and that they already get that. So I think that there are arguments to be considered against us doing it, and they're credible arguments. But I think that it's worth us giving it consideration as the full commission. I think that on balance, this proposal to pay legislators a salary that's equal to the median family income in New Mexico would help the representative government goal that I think we share. And so on balance, I think it's something we should approve, and I would move that we endorse it as a commission and go on record as saying that we're in favor of the legislative pay constitutional amendment.
Thank you, Stuart. He has made the motion to endorse, go on the record in favor of the proposed legislative pay amendment. Is there a second?
I second the motion.
Okay, then there's a motion and a second. Do you want to speak to it?
Sure. I'm not going to
everybody?
repeat everything that Stuart has said because I think he has pretty well presented, both sides of the issue. The things that that I think are important is I do think legislators ought to be paid because the work they do is tremendous. I agree they get per diem and they get their pension, but that doesn't really reflect all the hours that they put in to their job. I think it will help. They won't be so reliant on lobbyists, which I think is a good thing. I think it's a good thing to have a more representative pool of legislators, and I think this will do that. And I think what happens is once they get paid, there's more professionalism and there's more, they'll pass more things, I think, to recognize the importance of ethics in the legislature. I also think that once you have paid legislators, the public will expect more from them, and that will help us in our job. So I endorse the concept because I think on balance, it will promote good government and accountability. So that's why I'm seconding the motion. Thank you.
Thank you. Anybody else want to?
If I may,
Sure, Terry.
I am also in support of this. I introduced this bill in my last year in the legislature, and so obviously I support it. Our current legislature is not really a representative slice of our constituents in the state. Those who serve are those who can afford to do so and have the ability. We have a large contingent of retirees, and there's nothing inherently wrong with that. But we don't have a representative slice of our population because it's expensive to serve in the New Mexico legislature. So for all the other reasons that have already been cited, I support it.
Thank you. Anyone, Jeff?
Yeah, I have a question for Celia. You said that a paid legislature will be less reliant on lobbyists. Can you explain?
Yes, because they're not paid, often lobbyists go ahead and take them out to dinner and do a variety of things. I think you have more ability to say no to those kind of things when you're paid. Things are taken care of. So I think that's why right now I think lobbyists have quite an influence on legislators because of the system.
Well, let me just ask the question. I've obviously never been in the legislature. I assumed that the reason why lobbyists are so influential is not only because they can buy meals for a legislator, but they have the information on a particular bill that is helpful for the legislator. But now that there's staff, does that sort of undercut the importance of a lobbyist? That the lobbyist is no longer the sole source of information on a particular item?
I think, yes, it does help. And I do think that the staff does help. There's a lot more to it. Lobbyists also have the ability to provide money for the campaign funds. So I just think that while, yes, having staff helps, I do think that once you get paid, the reliance calculation changes.
Right, because I thought about this a little bit, um, with the caveat that my vote doesn't count. This will pass or fail regardless of what I say or do. Um,
All right, everybody, I'm going to note this is in the meeting because it's my duty to note the poor Jeff speech has already been given there. So we all note that
Thank
on
you.
our notes. Yes.
Thank you, Judge.
Okay, please go ahead.
But I thought that term limits might have an effect on how the legislature functions. Longer sessions would have an effect, and higher pay for the staff would also have an effect. And so my view is that it's a package of items that might improve what the legislature is able to do. And then my final comment is this really within the bailiwick of the Ethics Commission? Is this really something that's within our lane in terms of endorsing a particular amendment so that legislators can get a salary? But thank you.
Thank you. Anyone else? No? I would just say, the arguments for, and Stuart, you and I had a discussion on this, and so you and I have not, but I'm much more cynical in terms of what type of behavior this is likely to influence. If somebody is going to engage in corrupt practice, I don't think a salary is going to make a difference. I do agree with Terry that it will invite perhaps a number of people to run for office that might not otherwise see an affordable avenue to do that. So I think that's probably the best thing about it. They already get a retirement, which Stuart said, I'm baffled to see where that principle is allowed under the state constitution, but that ship has sailed, and fine, that's what it is. Lobbyists fundraise. Buying somebody dinner does not particularly bother me a whole lot, but again, I'm much more cynical as to what that's going to do. Oh, no, thank you. I have a salary. You can't take me to dinner. That's not going to happen, nor is that law going to change. But primarily, I default to where Jeff ended, and that is, I'm not sure this is within our bailiwick to endorse. I mean, why not? Where does this end? Do we endorse every piece of legislation because it may have some sort of ethical impact, small e or large e? So, I mean, I personally am in favor of it, but in terms of whether this is an appropriate action for the Ethics Commission to take, I'm not convinced that it is. I don't have strong feelings about it, but I do have feelings nonetheless. And again, the personal versus the governmental, there's a divide there. So, okay, so we call a question. Whether to endorse. There's a motion, a second to endorse and go on the record that the commission is in favor of HJR 5. Commissioner Baker?
The potted plant will pass.
Okay. Stuart?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
No.
Commissioner McMillan?
Yes.
Okay, Commissioner Villanueva?
No.
And the chair votes no. Somebody do the math.
Here, the motion fails for lack of 2 Republicans.
Okay, yeah, that weird quarter. No, that's right. We have, we only have 1. Okay, so the motion is deemed not well taken and is therefore denied. That's judge speak for it didn't pass. Okay, let's go to item number 6, voting structures of the Ethics Commission. Ms. Arreola. Good morning.
Hi, everybody. Good morning, Chair and members of the Commission. My name is Aurora Arreola. I am currently conducting a fellowship with my master's program with the New Mexico State Ethics Commission. And I believe everyone received a report that had a comparative analysis and situates New Mexico's statutory decision-making structure within the broader landscape of state ethics commissions across the United States. Ethics commissions are structured to advance shared institutional objectives that include independence, fairness, effectiveness, bipartisanship, and public trust. And as outlined in the report, most states pursue these objectives through statutory provisions, governing commission composition, appointing authority, quorum requirements, and voting structures. And in the report, you can see that New Mexico's model is distinct. The New Mexico State Ethics Commission consists, as you all know, of 7 members divided evenly between the largest political party and largest political parties and 1 unaffiliated member. And under statute, 4 commission members constitute a quorum, but that quorum must include at least 2 members from each of the largest political parties. And so similarly, no action may be taken without 4 affirmative votes, including at least 2 members from each of those parties. And so this structure conditions both quorum formation and commission action on bipartisan concurrence. And as a result, commission cannot meet or act without participation from both major parties. And the unaffiliated member cannot substitute for that statutory requirement. And so bipartisan in this context operates not only as a feature of commission composition, but as a governing rule of decision making. And so the report identified 3 general models used across other state ethics commissions. These models differ in whether and how statutory requirements incorporate political party affiliation into commission structure and decision making. And so the first model identifies that many states operate under majority rule with political composition requirements. In these systems, statutes limit the number of commissioners who may belong to the same political party or otherwise require some degree of partisan balance in appointments. For example, states such as Texas, Tennessee, Alaska include statutory provisions that restrict single party dominance or require representation from statutory provisions that restrict single party dominance. And so, however, these requirements apply to commission composition only. Once a quorum is present, decisions are made through majority voting, and statutes do not require that votes themselves be distributed across party lines. And the second model identified in the report was under majority rule without specific political composition requirements. And so in these systems, statutes do not structure the commission around partisan balance as a primary organizing principle. Instead, what they do is they emphasize other statutory requirements such as appointing authority, professional qualifications, or demographic representation. And as examples, you can see that in Alabama and Arkansas, statutes require representation based on criteria such as professional background, race, minority party inclusion, but they do not require overall partisan balance across the commission. And under these models, a quorum is typically defined as a simple majority of members, and decisions are made throughout standard majority voting. And importantly, political party affiliation doesn't determine quorum composition or voting requirements. The third model that was identified in this report was tiered voting structures, which focuses on how decisions are made rather than who must participate. In these systems, statutes distinguish between types of commission action. And so routine action decisions are generally governed by majority rule, while more consequential actions such as initiating investigations, issuing subpoenas, adjudicatory hearings, or making findings of violation require a higher threshold, often a supermajority compared to a majority. And so states such as Connecticut and Colorado illustrate this approach. These structures are designed to provide additional procedural safeguards of high stakes decisions without conditioning quorum or voting requirements on partisan participation. And so these models altogether demonstrate that states pursue the same institutional objectives through different statutory mechanisms. And independence is achieved through multi-branch appointments, structures, and eligibility restrictions. Fairness is reinforced through supermajority or tiered voting structures, and effectiveness is supported by quorum rules that allow commissions to meet and act consistently. And bipartisanship is typically embedded in commission composition rather than quorum or voting roles. And the key comparative distinction reflected in the report is that in most states, bipartisanship is a rule governing who is appointed in the commission. In New Mexico, bipartisanship is a rule governing who must be present and concur for the commission to act. So based on the national comparison presented in the report, you can see that New Mexico appears to be the only state that explicitly conditions both quorum formation and commission action on participation by members of two of the largest political party. I also want to note that it's important that to identify that some states have modified their voting structures over time, particularly with respect to investigation or enforcement action. So for example, Louisiana has increased the voting threshold for certain actions to a supermajority, while New York restructured its ethics commissions and revised its voting rules to address prior decision-making constraints. There are other states such as Missouri that maintain higher voting thresholds for formal action and in practice can affect the commission's ability to act under certain commissions. And so the comparative report is intended to support the commission's evaluation of how its statutory structure aligns with its core objectives of independence, bipartisanship, fairness, and how similar objectives are achieved through these alternative statutory models.
All right. Thank you. This is not obviously for any sort of approval or not seeking a motion, but is for informational purposes. Very well done, ma'am. Thank you. Anybody want to comment or ask questions? Yeah, Jeff?
Yeah, I just want to say, Aurora, this was impressive. This is excellent, excellent work. And I would very much like you and Jeremy to try to figure out where this might get published, where this might be sent, because I think it is a very important resource that other agencies outside of New Mexico might find helpful. And at some point, our legislature might find it to be helpful. So I'm very, very pleased with the quality of your work. Thank you.
Thanks.
Jeff, on
there were
on
other
that-
hands.
On
Yeah.
that point, if I may, Chair Jeff,
Sure.
We attend the Conference on Government Ethics Laws, the annual conference of state ethics agencies and local ethics agencies. And I'm hoping that that someone at the commission could present Aurora's work, and maybe we could invite Aurora to the COGO conference to present that work. Because I think that, we might not be the only agency that's thinking about voting structures, and I think that'd be a great avenue to take Aurora's work next. And yeah, while I'm talking, let me just say that we're very pleased to have Aurora kind of with us at the moment. She's funded by Thornburg, doing a Master of Public Policy at UNM, and we're just incredibly pleased to have that support and her academic work kind of to research the question, Jeff, that you're presently interested in. And yeah, hopefully that this report kind of gives spurring some additional thinking.
Thank you, Jeremy. Stuart, you had your hand up.
I did. I also want to thank Aurora for the excellent work. And I want to thank Jeff for bringing the issue to our attention and pushing it. I'm not prepared to make a motion on anything today, but I would like to ask the commissioners to consider whether, when we next propose legislative recommendations, that we ought to recommend a change in the voting requirements on commission action. And I don't think it's going to be feasible to change the requirement of at least 2 Democrats and 2 Republicans voting to pass anything out of the commission. So to ensure bipartisanship, which I think is a core goal of the people and the legislature in creating our ethics commission. But I think Jeff has made a good point, as the chairman calls it, his potted plant position. But I think that we could consider recommending to the legislature that in addition to the quorum requirement of 2 Democrats and 2 Republicans, that to pass anything for formal commission action should require 5 votes rather than at least 2 Democrats and 2 Republicans for those 4 votes. And if we did have a requirement of 5 votes, it would ensure the bipartisanship of the commission with at least 2 Ds and 2 Rs, and it would allow for the independent voice or minor party representative to have a vote that counts. It may or may not always be the case, but it would make it available. And it would build, I think, on the bipartisanship that is at the core of our unique commission structure, as Aurora described it here in New Mexico. And there are states, as she indicated, that do require a supermajority for taking certain actions, certain enforcement actions in particular, subpoena actions. And I think that it wouldn't do harm to the commission structure as it is to keep the 2 Democrat, 2 Republican minimum requirement and to add into it a 5th vote requirement, which would ensure that either another member of either party supports the measure, or that the independent or minor party representative supports the measure. So I would like that to just be something to consider. As I say, I'm not ready to make a motion about it now, but I'd be open to getting feedback and comments about it. And at least at this time, it's something I would like to have considered when we next consider our legislative recommendations, which I guess we usually do in November or December, to present to the legislature in the next session. And that was the suggestion I wanted to offer. So thank you, Mr. Chairman and members.
Thank you, Stuart. Anyone else want to weigh in on this? Yeah, Celia?
I'd just like to thank Aurora for her fine work. I enjoyed reading all the information that you provided and the way you organized it. So I just want to thank you for your fine work.
Miss Judy?
Yes, I also want to chime in on those comments regarding the quality of work that Aurora did. I do have a question, or I'd like some clarification on page 16. About midway down the page. In this particular paragraph, you're describing, I think, the composition of the statute that exists in the state of New Mexico regarding the composition of the commission. And so I'm going to just read this here. It says the statutory rule also has implications for the functional role of the commissioner unaffiliated with either major party. You say the DTS seat, period, and you have that in parentheses. Are you suggesting that extra seat that is non-majority is a DTS seat? Or should that say non-majority party seat? Because the current situation is that it is filled by a DTS individual.
Yes, thank you so much for that question. Yeah, I believe what I meant was DTS individual.
Current, not in the future, or not. Okay, just the current. Okay,
yeah.
Because if you can clarify this for me, so the statute indicates that it should be a person of a minority or non-majority party, correct?
Or independent.
Yes.
That's correct, Judy. And you will remember that there were Green Party members, there were Libertarians who applied when you interviewed a slate of candidates and ultimately chose Commissioners Baker and Solomon. But at that selection of interviews that the commission conducted back in 2019, I remember there being a Green Party member and a Libertarian.
the reason I'm asking is because my understanding is that in the state of New Mexico, there are only two minority parties. That's the Green Party and Libertarian. The Independent is a separate party, and DTSs are considered no party. So that's the only reason I'm asking for clarification. So in your explanation that this is the current composition of the commission, that's fine, and I appreciate your explanation. Thank you. It's a great piece of work.
Thank you, Judy. Yeah.
Uh-huh.
Anybody else? Okay, and I would echo the sentiments of my colleagues. Your work is exemplary. So that puts you in a small group, which happily consists of all of our staff members. So thank you very much, ma'am. And in my own defense, I believe Jeff knighted himself as a potted plant. I had nothing to do with that phrase, although I applaud it, but I did not so name him. Okay, on to item 7, advisory opinion 2026-02. Ms. Sue, good morning.
Good morning, Chair and Commissioners. I am excited to be presenting 4 advisory opinions to you today, and Becky will be presenting one as well. But first up is Advisory Opinion 2026-02 regarding agency considerations in amending a contract under the Governmental Conduct Act. So this request is from a state agency which entered into a small purchase contract for professional services with a contractor whose spouse then became an employee of another state agency. And the requesting state agency explained that it was already in the process of amending the contract in terms of its scope and compensation terms. And so the request wanted guidance on whether subsection 10-16-7A of the GCA, and this subsection is about public notice of the contract and competitive procurement. They were wondering if this subsection applies to the contract amendment, given that the contractor's spouse was not a public employee until after the original contract was signed. And so the answer to the question is yes. Subsection 10-16-7A of the GCA, which is about contracts between a state agency and a state public employee, family member of a state public employee, and businesses in which a state public employee or family member holds a substantial interest. And this subsection allows a state agency to enter into such a contract only if the public officer or employee has disclosed specifically through public notice that they have a substantial interest in the contract and if the contract is awarded according to a competitive process. So our analysis says that in terms of this amended contract, it would require public notice and a competitive process, because by changing the scope of the amount of compensation for the contract and the scope of the project itself, it basically makes the amended contract a new one. And this is important because it follows the spirit and purpose of the subsection 10-16-7A, and it safeguards against public employees using the powers or influence of their public employment to sway the awards of any contracts in favor of themselves or their family members. And it also ensures that contracts between public agencies and their employees and or family members are entered into after full disclosure in a merits-based process. And so if the agency follows this subsection, it is a way for them to ensure that the public won't suspect any self-dealing or insider advantages. Do we have any questions?
First, let's see. Do we have a motion and a second to approve the advisory opinion as put forth?
So moved.
Thank you. It's
Second.
been moved and seconded. Discussion. Anybody?
Good opinion.
Yeah, great work again. All right, there being no discussion on that, Commissioner Baker will call it to a question. Commissioner Baker?
Sure. Yes.
I'm sorry. Thank you. Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
And the chair votes yes. Thank you, ma'am. Great work. And we will next move on to Item number 8 on the agenda, 2026-03, Governmental Conduct Act considerations for local public officials holding local government contracts. Becky, I believe this is you.
It is. Thank you, Chair, Commissioners. This advisory opinion was an informal advisory opinion we did for a local municipality. Commissioner Bloomstone requested that it be made into a formal opinion, converted to a formal opinion. And so it's a little bit convoluted in that it has 3 requests regarding public officials and their subcontracts, contracts and subcontracts, and how they handle dealing with them once 2 are newly elected, 1 is already on the council. I'll go through it. Generally, I do want to note 2 things before I go into it. The first is that we did not do a procurement code analysis on this because this is a home rule municipality. And so the local ordinance regarding procurement is the one that governs. And secondly, Commissioner Bluestone did point out that we had a typo on page 62, paragraph 3, the first sentence, the municipality's current practices to ensure written disclosure by contractors. There's apostrophe and that was a typo, and that has been corrected. So let me go forth. The first issue is a new public official on the governing board. Is a subcontractor of Company A, which has a contract with the municipality to manage property. The public official owns Company B, which is the subcontractor, and then next year a new contract will go out for bid, and Company B, the new public officials company, wants to submit a proposal on that bid. In looking at this issue, we did analysis under the Governmental Conduct Act, section 1016-4, regarding official acts, and that it's unlawful for a public officer or employee to take official act for enhancing their financial interest. They should be disqualified from engaging in any official act directing their financial interest, unless it's a proportionately greater benefit to the general public than theirs, and no public officer during the term for which they're elected shall acquire a financial interest when the public officer or employee believes that the new financial interest will be directly affected by their official acts. So we also look at 1016-7B, which talks about a public officer must disclose the public officer's substantial interest through public notice, and that the contract must be awarded through a competitive process. So basically, in the first situation, the limitations on the public officer's action relating to the existing subcontract is the first matter. Yes? Did someone have a question? Sorry. Okay.
I'm sorry, is this real clear?
And basically, we have to say that under the Governmental Conduct Act, section 1016-7B does not extend to a subcontract between a public officer. However, we do address the issue that that cannot be used to circumvent the requirements of the Governmental Conduct Act that would otherwise apply. And so we talk about what the public official should do, that the contract, if it comes before the municipality, the public official must do a written disclosure, and the other acts that they must take. The municipality is permitted to enter in the contract with the public official, but can only award the contract following a competitive process, and the public official's substantial interest must be disclosed in writing through public notice. We also look at 1016-13, which addresses the use of or prohibits a local government agency from accepting a bid or proposal from a person who directly participated in the preparation of the specifications, to let the public official know that they cannot be involved with the drafting of the RFPs if they're going to bid. So basically, we go on to the second question, which is another public official wants to contract with the municipality. And they have a firm which is the only one in the area that provides certain services, and they already have a vast majority of contracts with the municipality and contractors and business owners in the general area. And prior to them being elected, they often spoke before the commission and advocated on behalf of companies' clients to the commission. So this one, it involves some of the same analysis as the first one. And we determined that the second public official is also permitted to contract with the municipality, but similarly must comply with recusal and disqualification provisions of 1016-4. Any contract with the public official must be the product of a competitive process, and the commissioner's substantial interest in the contract must be disclosed, and the public official may not be involved in the creation of the criteria or is for a certain bid, as well as submit a bid or proposal on the same project. They also must be careful not to misuse the powers and resources of the public office in any participation before the municipality's governing body. And we note that an official act does not just include a vote, it includes recommendations, kind of lobbying on behalf. So official act is larger than just a vote. So we notice that they must be careful on that. The final question is, there's another public official on the governing body who's a subcontractor on bids for municipal contracts. And so we use the same analysis that was set forth in the first two. And we come to the determination that, again, they can bid with the municipality. They need to make the same disclosures and comply by the same recommendations that were set forth before. And I think the overall conclusion, which is I think one of the most important, is that the best practices in this is enforcing full disclosure, maintaining transparency in procurement, and following the recommendations of written disclosure, disclosure of financial interest, competitive process, that the municipality needs those to ensure compliance with the Governmental Conduct Act. And so I stand for any questions.
Thank you. Is there a motion and a second to approve the issuance of the advisory opinion as outlined and set forth?
So
Move to
moved.
approve.
Thank you. Moved and seconded. Discussion? Okay, hearing none, then Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman. Gary, you're muted. Commissioner Klingman, are you with us? You're muted. Okay.
Okay, let's try that.
There you go.
Approve, I'm sorry.
Thank you. That's quite all right. That's quite all right. Commissioner McMillan,
I vote yes.
Commissioner Villanueva,
Yes.
Chair votes yes. Thank you, Becky. Nice work. That's a that was an interesting chain of loose threads, to mix metaphors. Okay. Item number 9 is, and that passes. Number 9 is advisory opinion 2604. Ms. So, it's you again.
Alrighty, happy to be back. This request is about the Governmental Conduct Act, and it asks if a person who serves on a school board, but who's also responsible for approving certain financial decisions for the same school board in their role as a state employee, can hold both roles despite a potential conflict of interest. And so part 1 of this opinion talks about how under the GCA, These dual roles are allowed so long as the person acts accordingly pursuant to subsection 10-16-3C, where they have to do certain things. So the first thing is they must fairly and impartially carry out their duties as both a school board member and as a state employee. And we give an example about how the person shouldn't do things like give unfair treatment in approving the budget for their own school board compared to the budgets of other school boards. And the second thing that they must do is disclose to their state agency employer any potential conflicts with the local school board, and also disclose to the local school board to the extent there's any potential conflicts in their holding of both roles. And third, when they encounter any situations where their obligations as a board member conflicts with their obligations as a state employee, they have to recuse from matters in their role as a state employee that would affect the school board. And this is really important because it prevents any functional incompatibility between the two positions under state law. And then part 2 of the opinion explains what this phrase of functional incompatibility actually means. And by doing so, we summarize the holding in a case called Haymaker versus State, which basically holds that in order to determine if the two roles are functionally incompatible, the relevant inquiry is if there is an inconsistency in the functions of the two offices, as where one is subordinate to the other. And so this case gives an example where there is a local school board member who then was chosen to be a state auditor, and how this individual couldn't hold both positions because by doing so, he would be the judge of the school board's financial decisions and actions in his role as an auditor. But then in his role as a school board member, he would likely have to make financial decisions. So there's a direct conflict and incompatibility there. And then next in our advisory opinion, we discuss another case, and it's called Amador versus the New Mexico State Board of Education. And this case gives an example of when holding two roles would actually be okay and would be compatible. And the example it talks about is how it's okay for a school teacher to also be a member of the State Board of Education, because there likely wouldn't be a lot of conflicts in which that teacher would be involved unless there was, you know, a discussion on the teacher's own role or discipline in their role as a teacher in front of the school board. So that is my second opinion that I'm talking to you about today.
Thank you. Thank you very much. Well done. All right. Is there a motion and a second to approve the advisory opinion as set forth and discussed?
So moved.
Thank you. Moved and seconded. Any discussion?
I just want to
Sure.
say again that these opinions are very well done.
Yes.
Thank you, Ms. Sue. I think that we do a real public service, both by answering the informal requests that come in so promptly and so thoroughly. And then when we convert them into these formal commission opinions, I think it has more general publication and general accessibility to people throughout the state. And I think it's very helpful. So I just want to commend you again for this excellent work. And I think it's an important role that the commission performs in approving these.
Thank you, Stuart. Amen to that. Anyone else? All right, let's call a question. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes?
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan?
Yes.
And Commissioner Villanueva?
Yes.
Right, and the chair votes yes. Again, applause for the good work, and the advisory opinion 2026-04 is hereby approved and let it issue. All right. I'm sorry, that's 2026-06. Now we'll move on to item 10, which is 2026-04. Okay, ma'am, you're still up.
All right. Well, thank you everyone for your kind words about the advisory opinions, although I would have to give credit to Casey for these, and also credit to Casey for mentoring me before she left for parental leave. But I'm learning a lot and having a great time, and I really enjoy doing this. So the The next advisory opinion is related to campaign expenditures for media related to lawsuits arising from legislative duties. And this opinion addresses a question about section 1-19-27.1 of the Campaign Reporting Act and asks if a former legislator can use campaign funds to buy a newspaper ad explaining a lawsuit that resulted from their work in legislative office, specifically to share the outcome of that lawsuit and to inform the public about what happened. And the answer to whether they can use these funds or not is yes. The former legislator can use campaign funds for press expenses incurred in connection with legal proceedings arising directly from the legislator's official duties as a legislator, so long as the expenditures would not exist if the legislator had not held legislative office. So the text of the Campaign Reporting Act specifically provides that it is unlawful for a candidate or the candidate's agent to make an expenditure of contributions received, except for 1, expenditures of the campaign, or 2, expenditures of legislators that are reasonably related to performing the duties of the office held, but excluding personal expenses. And the New Mexico Secretary of State has promulgated a regulation that follows federal law in the Federal Election Campaign Act and interprets the term personal expenses in the following way. So basically, personal use of campaign funds is any use of funds in a campaign account to fulfill a commitment, obligation, or expense of any candidate or legislator that would exist regardless of the candidate's campaign or responsibilities as a legislator. If the expense would exist even in the absence of the candidacy, or even if the legislator were not in office, then it is not considered to be a campaign-related expenditure. And so in writing this advisory opinion, there wasn't any state case law applying this personal use prohibition, so the analysis looks to federal law. And the Federal Election Commission has issued several advisory opinions related to the permissibility of paying for media expenses related to legal actions. And federally, it has consistently held that campaign funds may be used to pay for expenses incurred in responding to press inquiries regarding legal actions arising out of allegations related to a candidate's campaign activities or duties as a federal officeholder. And the commission has also previously reviewed this question about using campaign funds to cover legal expenses. And looking to that, along with the federal authorities, in this opinion, we conclude that a former legislator may expend campaign funds for press expenses in connection with legal proceedings arising directly from the legislator's official duties, so long as the expenditures don't constitute personal use and would not have existed if the legislator did not hold that legislative office.
Thank you very much. Is there a motion and a second?
So moved.
Second.
Thank you. It's been moved and seconded. Any discussion as to whether to approve and issue advisory opinion 2026-05? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes.
Commissioner McMillan,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. So as with the previous item, which I think I misidentified, but no, item 9 on the agenda was the issuance of 2026-04 advisory opinion. This too passes, which is item number 10 on the agenda, 2026-05 advisory opinion. And next on to your last one. You got a lot of work going on these days, ma'am.
Yes,
Go
they
ahead
keep me
with your
busy
next.
here.
You always do. Go ahead with advisory opinion 2026-06.
Thank you. So this opinion also answers a question about holding 2 different roles under the Governmental Conduct Act. We've been getting a lot of questions about this, formally and informally. And specifically, this request asks if an individual can simultaneously be a board supervisor for the State Soil and Water Conservation District, and whether they could be the New Mexico Secretary of State. And part 1 of the opinion explains how the GCA would not prohibit someone from holding both roles for the following reasons. So first, when we look at subsection 10-16-4 of the GCA, which talks about how a public officer or employee's financial interests cannot, in general, be taken to directly enhance personal financial interests through official acts. But given the facts in the request, employment as the Secretary of State would constitute a financial interest, but the position of being a board supervisor would not constitute a financial interest. And so because the requester doesn't have a financial interest in their position as a board supervisor, this subsection would not require disqualification in the role of Secretary of State. And because the board supervisor position also doesn't include any official acts that would affect the role of Secretary of State, this subsection is unlikely to apply. And second, the opinion discusses subsection 10-16-3C of the GCA, which talks about how government positions should be treated as a public trust and how there has to be disclosure of real or potential conflicts of interest in order to avoid undue influence and abuse of office in public service. So applying the facts here, if the requester were to be elected Secretary of State and also maintain their position as a board supervisor, they would need to be able to perform both positions faithfully and impartially. And if the requester runs into any potential conflicts of interest, they should disclose the conflict and decline to take action that would breach the public trust for either position. And lastly, part 1 of this opinion states that the requester also needs to disclose their position of Secretary of State to the Conservation Board under subsection 10-16-3A. And really quickly, I'll talk about part 2 of the opinion as well, which talks about incompatibility under the Governmental Conduct Act in terms of physical and functional incompatibility. And we've already talked about what functional incompatibility means. We talked about that earlier today, so I won't go over that again. But in terms of physical incompatibility, the GCA basically just explains that if for a period of 30 successive days or more, a public employee or official doesn't work to the normal extent during normal working hours for their position, they would then be deemed to have resigned from and to have permanently abandoned their public office and employment. But given the facts in this request, where being a board supervisor only involves part-time duties, so long as the requester meets the requirements of the position of Secretary of State and otherwise seeks appropriate accommodations to permit any leave, it's unlikely that these positions would be considered physically incompatible. So thank you all for listening for so much.
Thank you. Thank you very, very much. Is there a motion, a second, to approve advisory opinion 2026-06?
So moved.
Second.
Any discussion? All right, seeing no raised hands, Commissioner Baker, do you approve?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
And the chair votes yes. Grace, thank you very, very much. That was really, really well done. There was a lot of stuff going on there. Okay, there's Amelia right on time. Public comment, you want to check for us?
Thank you, Chair, and hello, Commissioners. I don't see any members of the public here today.
Well, that would probably limit the public comment section. So none. All right. Chair will entertain a motion to go into executive session pursuant to section 1015-1H3, 1015-1H12, and 1015-1H7 to discuss the matters identified in sections 13 and 14 of the agenda. Is there such a motion?
So move.
Second.
All right. Commissioner, I'll do a roll call. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes.
Commissioner McMillan,
Yes.
Commissioner Villanueva,
Yes.
Chair votes yes. All right, we'll go into executive session and we will reconvene in said room in approximately 5 minutes. We'll take a short break in between. See you on the other side. Thank you.
Thank you.
Please join the breakout room.
Stuart, what's going on up in Santa Fe these days?
Not much water. I'm sure it's true down in your area too, Gary.
That's the same.
Yeah, it's very, very scary as we head into the fire season.
They get any snow up in the mountains?
Very little. I think they're talking about it as being 10% to maybe as high as 30% of normal, but it's very, very bad.
Okay,
Very,
we
very
are
dry.
back in open session, and as chair, want to state that only those matters which were discussed in the matters discussed in the closed meeting were limited only to those specified in the motion for closure pursuant to statute. So with that, we'll go to item number 15. Becky?
Sorry about that.
It's all right.
Chair, Commissioners, staff request issuance of a default order in 2025 NP 21.
Okay, is there a motion and a second?
So move.
Second.
Thank you. Any discussion? All right, so we will have a roll call vote to determine the appropriateness of the recommendation of the commission staff. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes.
Commissioner McMillan,
Yes.
Commissioner Villanueva,
Yes.
and the chair votes yes. Thank you, Becky.
Thank you.
Item number 16, authorization of the civil action, 16-1. Zach or Connor?
Thank you, Mr. Chair, members of the commission. Staff seeks authorization to make a demand and file a civil action against the Republican Party of San Juan County to enforce the Campaign Reporting Act.
Okay, is there a motion, a second to so authorize?
So move.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker, are you in favor?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan?
Yes.
Thank you. Commissioner Villanueva?
Yes.
And the chair votes yes. Thank you. Roman numeral 2 is deferred until a later meeting, and Roman numeral 3, Jeremy?
Thank you, Chair. The staff seeks an authorization to file a civil action against the Virginia Non-Stock Corporation Elevate New Mexico to enforce Section 6I of the Lobbyist Regulation Act.
Thank you. Is there a motion and a second?
So moved.
Second.
Thank you. Any discussion? Hearing none. Are you in favor of the authorization, Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Klingman?
Yes.
Commissioner Castillo? Sorry.
Yes.
I shouldn't try to do two things at once. I should have learned that this morning or earlier at home. Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
And the chair votes yes. Thank you. All right, the next item is number 17. I was made aware the other day of a medical appointment that I kind of need to have, and they've moved me to June 5th, which would be ordinarily our first day. Is everybody okay? And Stuart, I recognize you're going to be essentially gone for a couple of months. And because of the next item that we'll discuss, I don't want to run it out too far, but is everybody okay with June 12th, recognizing your constraints, Stuart?
Chair,
Yeah, I can participate by Zoom.
Chair, I will be in Traverse City with my old friend Pete Buttigieg on June the 12th.
Okay. The 19th?
19th looks good.
Two things. One, that's Juneteenth. I don't know if that's a holiday in New Mexico.
It is.
And I'm going to be in Atlanta to attend the World Cup.
Good for you.
So,
Good for you.
indeed, going to watch Spain play Saudi Arabia.
Ooh,
Who should I root for,
yeah.
Mr. Chair?
The great game. It's the beautiful game. So
But obviously, I don't need to be at the next meeting
What about May 29th?
if it's not convenient for everybody else.
all right, what about May 29th?
But I mean, May 29th?
Yeah.
Hold on. Okay
Is
for
that-
me.
Is that okay with staff?
I won't be able to make May 29th, Chair.
Okay.
All right, that if we're gonna stick to a Friday, that leaves June 26th. Which I don't know that I've even checked that, but something tells me that's not a good day.
If the 19th works for everybody else, I would just recommend the 19th.
Chair.
Yeah, and the chances are what time of day is your game?
Well, the game is actually on Sunday, on Father's Day,
Okay,
but I'll be traveling.
okay.
Chair,
Let's-
I'll be in an
29th
airplane.
is a state holiday.
That's right. Is it on the Monday or is it on the actual day?
It's on June 19th.
Okay,
The
how
Friday.
about 2021? How about the 22nd? That's a Monday, but let me before we do that, okay. The next meeting is going to be in person. I have notified the governor's office of my desire to not be reappointed. Again, sounding presumptuous, I do not want to be, but my term expires June 30th. So this will be my last meeting. I can't commit whoever the next chair is to anything beyond June 30th. So we can't go into July. We're out of Fridays in June. Is everybody okay with something like, well, let's go back. If we're going to look at a Monday, let's look at the first Monday would be 8th.
Okay, you may have the judicial conclave. I don't know if you go to that.
No, I don't.
I'm not
a
going
retired-
either.
No.
Nor am I.
So the 8th is okay.
That works.
Is everybody else okay with the 8th? Is
I
staff?
can't do it by even Zoom on the 8th.
Okay.
I'll be
Jeremy,
flying.
Jeremy, what's staff?
We're fine for the 8th. Yeah, we're fine for the 8th. We're fine for the 15th. If you want to look at a Thursday, we're fine for the 4th. We're fine for the 18th.
What about the 4th?
I'm not good on the 4th.
No. Me neither.
Neither am I.
No. 4th is no good. 5th is no good. 8th is okay. What about the 11th?
11th is good.
11th is good.
That works.
That's a
That's-
Thursday.
The 11th, I'm out of state.
Okay.
Okay, you mentioned the 18th or the 15th?
Yeah, how about the 15th?
15th is good.
I'm good.
Not good or good? I couldn't.
Yes, for the 15th.
You okay with the 15th, Jeremy?
Yes, sir.
Are you okay with can you try to make that, Stuart?
By Zoom.
Yeah,
I can do
by
that.
Zoom, obviously. Okay, then the next meeting will be June 15th, which is a Monday. I try to do Mondays and Fridays since we're going to do it in person. If that presents a problem with you folks who have to travel in, let me know now. Let us know now.
You could set it at 10 o'clock in the morning. That would probably.
Yeah, we can do that. That gives you a little time.
Yeah.
Extra time, but now it also gives you the Sunday if you want to come up. So,
Yeah. Chair, Wendy and I have budgeted for commissioner travel for this. So if
Okay.
Commissioners Villanueva and Klingman want to come in early, it's all budgeted for.
okay. But so that they don't have to decide right now, let's go ahead and schedule it at 10 o'clock.
I said Monday, the 15th of June,
Right.
and this is your going away party?
It's an in-person meeting at the strong suggestion of a senior staff member. And yeah, it'll be my last meeting. I have sent notice to the governor of my desire to ride into the sunset, and I assume that was received. I have not heard back from her chief of staff or general counsel, to whom I sent the email to notify, but I'm assuming they received it. Jeremy's going to follow up with that, I'm sure, at some point. But that'll be June 15th. Everybody good?
Chair, will that be in Santa Fe or will that be in Albuquerque?
No, in Albuquerque.
Okay.
Thank you. We've tried Santa Fe a couple of times, seemingly it's appropriate, and we get even less participation up there than we do here. And which is not to say we'll have anybody here, but okay. And with that, Amelia, we got any public to comment?
Thank you, Chair. I don't see any members from the public still.
Okay. In which case we will stand in adjournment. Thank you, everybody. Have a
Bye, everybody.